CV 2020-00599. It's a telephonic hearing. The motion or the oral argument regarding the war employment records is being vacated this morning. And instead, I wanted counsel on the line so I could discuss another matter. Who do I have on the line today?
Your Honor, you have Lynn Cadigan for the plaintiffs on the line, as well as Taylor Boren.
Good morning, Your Honor.
Good morning. Is anyone else on the line this morning?
Yes, Your Honor. Good morning. It's Bill Maladon on behalf of the church defendants, and along with me is my co-counsel, Joel Borowitz, and also my co-counsel, Peter Schofield.
Good morning, Your Honor.
Good morning.
Good morning, Your Honor. Ann Chapman and Kathy Brody, representing Ms. Moore, are also present on the line.
Good morning, Your Honor.
Good morning. All right.
Good morning, Your Honor. This is Michael Ryan on behalf of the medical malpractice defendants, Dr. Harrod and Lindstrom.
Okay. Anyone else? Okay. Well, I wanted to take a minute, first of all, and indicate that I did get a copy of the recent motion to have me removed for cause. And what I wanted to do on the record was basically say that I have read the motion. I do think that the information provided does at least rise to an appearance of impropriety. And so what I wanted to do is give the parties an option and get feedback. The court is willing, based on the information provided in the motion, to recuse itself from this matter right now. I would open it up for objection if anyone has any, or the parties can continue forward and let the presiding court make the decision. I also want to put on the record that I don't believe that, well, just for context, this is a small community, and I know that the attorneys that operate in Tucson and Phoenix have a different context that they operate in. I spent the first half of my career prosecuting people that I went to school with and that I was one person removed from or less on a regular basis. So the court does understand that my tolerance for conflict is probably quite a bit higher than most people, maybe even most people in Cochise County being small. So I regret not being more open, given the sensitivities of this case in regard to my history with the church. I don't tend to believe it would cause me personal bias, but there's no way for any of you to know that, and the appearance is absolutely there 100%. So does anybody have any objection or comment before I make the decision as to whether to recuse right now or let the presiding court or judge make the decision?
Yes, Your Honor. This is Lynn Cadigan for the plaintiffs.
Ms. Cadigan, proceed.
This is my concern. The rules are very clear that they have 20 days, the defendants, to raise these concerns when they learn about them. And what they're basically saying is because you were at one point a member of a small church, you can't be fair, and that you quote, what they say is, importantly, Judge Lindstrom has never disclosed these important facts to the party. I think that's very surprising and very devious, because I knew you had been a member. Everyone knows that. And who knows that the best? The church does. You're on their roll. So the very person who submitted an affidavit knew you had been a member. The reason they didn't strike you in the beginning, the reason they didn't bring it up, is they thought because you were a member of the church, they would get a favorable ruling. It's kind of obvious, because the minute, as you well know from the last hearing, they thought they were going to lose something, they then filed this in violation of the 20-day requirement. I think that if they had a concern, they should have raised it within the 20 days. The only reason they're raising it is because they didn't like what happened in the last hearing, which is exactly why you have a 20-day requirement. And I doubt, as you well know, and as we all know, the church knows better than anyone else that you were a member. You were on their rolls. It was a 50 to 75 member ward. They all knew. I knew that you had. If I knew in Tucson, clearly the church knew. I didn't raise that as an objection in the beginning because I think you can be fair. I just find it shocking that they would cast aspersions on your ability to be fair in an untimely manner, which violates the rule. And I would like the matter to be heard by the presiding judge.
Okay, thank you, Ms. Cadigan. Any other comments on what I've proposed?
Yes, Your Honor, it's Bill Maladon, if I may. First of all, I want to say that I think Ms. Cadigan's argument is nothing short of outrageous. She's accusing us of having knowledge that we kept to ourselves, and that's simply not true. Secondly, the 20-day rule applies only under Rule 42.2, and we have moved to change judge under both 42.2 and 12409, which is the removal of a judge for cause. And when I say cause, Your Honor, I and the other defendants are not in any way suggesting that Your Honor has done anything inappropriate or that Your Honor has demonstrated bias. I have a client to represent, Your Honor. I've been practicing law in this state for 42 years. And I have never run into the kind of unethical lawyers that I'm dealing with on the other side in this case. I have never run into lawyers who think that the rules of civil procedure don't apply to them. And they file things like surreplies, which aren't permitted under the rules. And they take
Your Honor, I would object to this. I thought this was about you're not following the rules, not about the plaintiff's lawyers.
I'm getting to the point, Your Honor. I didn't interrupt Ms. Cadigan. I'd appreciate it if I'd be allowed to continue. My point is this, Your Honor. I have a client to represent. And what's going on in this case is very, very important to the ultimate outcome of the case. For example, Your Honor, Ms. Cadigan says that we knew longer than 20 days all the things that were in our motion that we filed. That's just untrue, Your Honor. When we had the hearing and you made the statement on the record about knowing things about the Mormon church and expressing some points in that regard, as we said in our motion, we did an investigation. We didn't know until just recently that Dorothy Peterson is your mother-in-law. We actually talked to her a month or two ago without knowing that she was your mother-in-law. We would never have done that if we had known that she was your mother-in-law. So, Your Honor, there are a lot of things that came out as a result of that hearing that gave us a level of discomfort that we thought it was appropriate for us to file that motion. I have only filed one other motion in my entire career to disqualify a judge. So I don't do this lightly. But I did it in this instance, Your Honor, because this is an important case to my client. And there are things going on here that are very concerning to us. And Your Honor, if it were just the fact that you're a member of the church, we might not have filed that motion. But Your Honor doesn't know the half of what's going on in the county attorney's office between Ms. Cadigan and the county attorney. We have filed a
Mr. Maladon,
public records request for
Mr.
all the
Maladon,
communications between them.
Mr. Maladon, I'm going to stop
Yes, Your
you
Honor.
right there because I tend to agree with you that, I tried to keep the case, and I did know that it involved a ward that I had some familiarity with. And my reason for keeping it was because we were running out of attorneys to give, or judges to give it to. I think we have one left in line, and then we're going to have to give it to someone out of county, which may end up happening anyway. I was trying to avoid that. I was aware that my mother-in-law was a member during that time. All I can say is no one ever shared any information with me, and I didn't expect that she would ever be called, but I think just talking with her alone is probably enough to where I just to avoid any appearance, should have recused myself anyway. I'm new to civil, I'm new to the bench, I'm going to make mistakes along the way. I think my lack of full disclosure in the very beginning was my mistake, and I think it does rise to a threshold where I'm not sure if people would have objected had I revealed everything on day one, but I can't really speculate, and I have to assume that you would have, and therefore I do tend to believe that I should recuse myself. But now my concern is, can I recuse myself, or do we have to let the presiding judge make the decision? Is there any rule anyone can point to that would prevent me from recusing myself today?
Your Honor,
No, you-
Your Honor, I would just like to put on the record that Mr. Maladon, although we filed something saying that you violated the rules by not disclosing this, has spent most of his arguments personally attacking me instead of addressing the real issues in the case, which seems to be their only defense. And again, I have been a lawyer. I mean, I know I'm not a man. I don't stand up for 41 years, but I have represented sex abuse victims against churches and institutions for 38 years. And I have never seen someone file this kind of affidavit once they have a bad hearing. You know, they thought they had you in their pocket. And so I just would like to put on the record that to be accused of doing unethical things by a lawyer who has accused you, the judge, of doing unethical things, when he himself knew you were a member of that tiny little ward, they knew all this, and you know they knew it. They just thought it would help them. Now that it's not helping them and you're showing yourself to be fair, that's why they want you off. And I think for your personal reputation, I think it would be much better to have it ruled on by the presiding judge. Anyway, I just wanted to say that because I'm personally shocked by the level. I mean, even the Catholic Church didn't think this low.
I appreciate your comments and yours as well, Mr. Maladon. However, at this point in time, I'm not in a position where I can speculate as to what the parties would have done had I revealed all these facts right up front. It's possible that no one would have objected and I would have remained on the case. It's also possible that someone would have objected to some of these relationships. I have no way of knowing because I didn't do it. And for that reason alone, if nothing prohibits me from recusing myself at this time, based on the nature of the case, based on my connections to that small ward where the case is centered, and my relationship with the county attorney's office, even though I had no involvement in the prosecution in this matter, I do think that at the very least there is reason to believe that there's an appearance, at least an appearance of impropriety. And for all those reasons, I think I, at this point, have to recuse myself. I don't think it would make any difference, because quite frankly, if it were to go to Judge Dickerson and he were to rule in favor of Ms. Cadigan, at this point in time, I almost feel like I have to recuse myself on my own terms anyway. So thank you all for your comments and for assisting me in making this decision. There will be a minute entry order going out today indicating my recusal, and this case will be reassigned. I wish you all the best. This has been complicated dealing with this number of attorneys, and I'll try to make the transition to the new court as smooth as possible to the extent I can. Thank you for appearing today, and all of you have a nice day.
Thank you, Judge. Thank you, Your Honor.
Thank you, Your Honor.